Welcome to the deep dive. Today we're tackling a really fundamental bit of the legal world,
Mm.
figuring out who can actually step into court. Who gets to be a party in a legal action.
Yeah, it's like understanding who gets a ticket to the game, basically.
Hmm.
Who can bring a claim and who can be on the receiving end.
Exactly. And we've got quite a range of stuff to look at. Rules from England, Zambia's high court rules, bits from the Companies Act, Land Act, State Proceedings Act, and a bunch of Zambian cases, too.
It's interesting how they all fit together, isn't it? You get the rules, but then you see how the courts actually, well, apply them in real situations. Gives you a proper feel for the landscape in Zambia.
For sure. So our mission, if you like, is to cut through the legal jargon and give you a clear, kind of practical handle on who has legal standing in Zambian courts. Make it accessible.
Sounds good. Where should we start?
Okay, let's dive in with something foundational. The rules around minors and individuals who might lack the capacity to manage their own affairs. Persons under disability, I think is the term.
Right. That's a key area. The basic idea, which comes from Order 80 of the English Supreme Court rules, and it's very influential in Zambia, is that kids, anyone under 18 or someone who isn't mentally capable of handling their own legal stuff, they can't just start or defend a lawsuit themselves.
That makes sense. Protects vulnerable people.
Exactly. The law is really concerned about protecting them in, complex legal fights.
So you wouldn't want someone who doesn't fully get the consequences making big legal decisions alone. How does the system make sure their rights are protected then?
Well, that's where you get the next friend for minors.
Yeah.
And the guardian ad litem for patients, as they're called.
Okay.
These are basically responsible adults the court appoints. Their job is to represent the interests of the minor or the person lacking capacity, acting in their best interests, essentially.
Like designated advocates within the whole process. And that case you mentioned, Felicitas Mwaba, that shows it in action.
Precisely. You had two minors suing through their father who was acting as their next friend. Clear example.
Yeah.
And importantly, this next friend or guardian isn't just acting on their own whim. Order 80, Rule 2 says they must act through a solicitor.
Okay. An extra layer of legal expertise.
Yes, it makes sure things are handled properly by someone qualified. The notes on Order 80 actually say this, is to shield these vulnerable people from, ill-advised lawsuits or prejudice.
Good safeguard. Now, what if things change after a lawsuit has started? Say someone involved passes away or becomes incapacitated. Does the case just fizzle out?
Not usually. That's where the idea alteration of parties comes in. It's covered in Order 16 of the Zambian High Court rules.
Okay.
The law gets that things change mid-case. If someone dies or loses capacity, or maybe their legal interest gets transferred, the court can step in.
So the system can adapt. It doesn't just grind to a halt.
Pretty much. The rules let someone with a proper interest apply to the court for an order to cure the defect, as they put it. Basically, fix the party list so the case can carry on correctly.
Makes sense. Keep things moving fairly despite life happening.
Yeah, ensures disputes can still get resolved.
Okay, sticking with that theme, death. Let's talk executors and administrators. They manage a deceased person's estate. How do they fit into this who can be a party picture?
Right. Since a deceased person obviously can't go to court, their legal representatives, executors, if there's a will, administrators, if not faint, they essentially step into the deceased's legal shoes.
So they get the power to sue or be sued for the estate.
Exactly. They have the legal capacity to start or defend lawsuits on behalf of the estate.
And if the person who started the lawsuit, the plaintiff, dies mid-case?
Order 16, Rules 4 and 5 of the High Court rules cover that. If there are other plaintiffs still in the case, the legal rep of the deceased can apply to be added alongside them.
Okay.
If the deceased was the only plaintiff, then the legal rep can apply to be substituted in, basically taking over the lawsuit.
What if no one applies?
Well, if no application is made within a reasonable time, the court can order the suit to abate, which just means it's terminated. Done.
And what if there's a fight over who the actual legal representative is? That sounds like it could gum up the works.
It could. Rule 6 of Order 16 anticipates that.
Yeah.
If there's a dispute about who the rightful rep is, the court has options. It can either pause the main lawsuit until that separate issue is sorted out.
Right.
Or if it's straightforward enough, the court might just decide who the rep is for the purpose of this specific lawsuit. Just keep things moving.
Practical. Avoids getting bogged down in side issues.
Exactly.
Okay, let's switch gears. Trusts. I usually think of a trust as, well, an arrangement for assets, not really a legal person.
And you're mostly right. But the Land Perpetual Succession Act in Zambia carves out a specific exception. if a trust is registered under that act.
Yes.
Section 2 effectively turns the trustees into a body corporate. It gives them perpetual succession and a common seal.
Okay, unpack body corporate for me. And perpetual succession, common seal.
Sure. Body corporate just means the registered trust gets its own legal identity, separate from the individual trustees at any given time. Perpetual succession means the trust itself keeps existing legally, even if the trustees change over the years. Death, retirement, whatever. And the common seal is like its official signature.
So the key point is...
The key point is this legal status lets the registered trust sue and be sued in its own corporate name. So you'd sue the XYZ Trust, not Mr. Smith and Mrs. Jones, the trustees.
Got it. That clarifies it nicely. Now, companies, they're definitely legal entities, no question there.
Oh, absolutely. Section 22 of the Zambian Companies Act is pretty clear. It says a company has the capacity, rights, powers, and privileges of an individual, within the limits of the act and being a company, obviously.
So suing and being sued is straightforward for them.
Fundamentally, yes. They can do it in their own name.
But I feel a but come in. Is there a rule about how they appear in court? Order 5, Rule 6, maybe?
You got it. That's the important rider. While they can be parties, Order 5, Rule 6 of the RSC, which is widely followed in Zambia, generally says companies must be represented by a solicitor in court. Well, there might be rare exceptions if a specific law says otherwise, but the general rule is company in court, solicitor needed. Ensures professional handling.
Okay. Now, this gets really interesting. What if a company goes into receivership? Who calls the shots legally then? Who can sue or be sued?
Right. Receivership. The key case to look at there is Magnum Zambia, Limited v. Basic Quadri.
And what did that establish?
It basically laid down the principle that once a company is in receivership, it generally loses its own power to start or defend legal actions.
So the directors can't just sue someone?
Not usually. During the receivership, it's typically the receiver who holds that power, and they act in the company's name, but indicating receivership, like Avalon Motors Limited in receivership.
The receiver takes over the legal reins?
Generally, yes, but there are exceptions. The later Avalon Motors case carved out some important ones.
Such as?
Well, what if the receiver themselves is the one accused of doing something wrong, maybe breaching their duties? Or what if the directors want to challenge the receivership itself, argue it wasn't validly appointed?
Okay, that makes sense.
In those kinds of situations, the directors might still be able to use the company's name to bring a legal action. Same if there are, vital company interests the receiver's just ignoring.
So there are safety valves if the receiver isn't acting right, or if the whole basis of the receivership is questioned?
Exactly. You need ways to address those scenarios.
Okay. Let's shift again. Partnerships and firms. How does legal standing work for them? Seems different from a single person or a registered company.
It is a bit different, yeah. Under Zambian practice, if you're an individual trading under a business name, someone can sue you either in your own name, trading as the business name, or they can just sue the business name directly.
Okay. And for partnerships, like 2 or more people?
They can sue or be sued using the firm's name.
But if the firm gets sued, who actually gets the court papers? Who responds?
Good question. Even though the action's against the firm name, the individual partners are the ones ultimately on the hook. So court documents have to be served on and acknowledged by the individual partners.
Right.
And to make sure everyone knows who's involved, Order 14, Rule 7 of the High Court rules lets any party ask for a list of all the partners' names.
Useful. And we saw a case where a firm sued in its name.
Yes, the Rating Valuation Consortium case is an example of a firm suing in its business name. But remember, you can always choose to sue the partners individually instead.
So some flexibility there.
Yeah.
Now, what about groups that are even less formal, like a residents association or a sports club that isn't registered as a company, unincorporated body?
Right, unincorporated bodies.
Yeah.
The general rule hammered home in the National Milling case is that these types of associations aren't legal persons. They don't have their own legal identity, meaning they cannot sue or be sued in their own group name.
So the Springfield Book Club can't just file a lawsuit?
Nope. If that book club wanted to sue someone, or if someone wanted to sue the club, it would usually have to happen through one or more members acting as representatives for everyone else.
Representatives again.
Exactly. The Major Kachingwe case involving a political party touches on this. Political parties are often treated as unincorporated clubs unless specifically registered otherwise. And way back, the Nkumbula and Kapwepwe case confirmed the common law idea. If loads of people have the same interest, one or more can sue or defend on behalf of the whole group.
So it always comes back to having an actual person or people standing in for the group. But some organizations do get special status from the laws that create them, right? Like ZIALE or the Law Development Commission.
Correct. Those are statutory bodies. The acts of parliament that set them up often explicitly give them corporate status, legal personality, which includes the power to sue and be sued in their own names, just like a company.
Okay. Now let's look more closely at these representative actions. Seems like another tool for dealing with big groups of people involved in the same issue.
It is. Order 14 of the High Court Rules and Order 15 Rule 12 of the English RSC cover this. The idea is if you have a large number of people, numerous persons at the term, who all share the same interest in a legal matter.
Meaning same rights, same potential liabilities, same defenses.
Exactly. Then the court can allow one person, or maybe a few people, to sue or be sued on behalf of the entire group.
But it has to be genuinely numerous, not just, say, 3 people.
Probably not. 5 might even be borderline. It's meant for situations where joining everyone individually would be impractical.
And the group being represented needs to be spelled out clearly from the start.
Absolutely. The writ or originating summons has to define the group or class of people being represented. And critically, the person named as the representative plaintiff is the one controlling the case, right up until judgment.
And the National Milling case confirmed this principle too?
Yes, it reaffirmed representative actions for numerous people with a common interest.
Okay. And what if you need to sue the government, the state itself? Special rules there, I assume.
Definitely. Section 12 of the State Proceedings Act is the key here. It's very direct. Any civil proceedings by the government or against the government must be started by or against the Attorney General.
So the Attorney General is the designated legal face of the state in court.
That's the procedure. Centralizes things.
Right. Finally, let's talk about changing the players after the game has started. Adding, removing, swapping parties, joinder, non-joinder, misjoinder.
Yes, things can get complicated midstream. Order 14 of the High Court Rules is the main guide here. It gives the court a lot of flexibility.
How so?
Well, if it turns out someone should have been included but wasn't, that's non-joinder, the court can order them to be added as a plaintiff or defendant. It can even pause the hearing to make it happen.
And if someone's in the case who shouldn't be?
That's misjoinder. The court has the power to strike them out, remove them from the proceedings.
And the crucial point.
The crucial point is the rules say a lawsuit shouldn't just fail because of a mistake in joining parties. The aim is to fix it, not throw the whole case out.
The Supreme Court has weighed in on when you can make these changes too, right?
Yes, they've given important guidance. In the Attorney General v. Tall, they said at or before the hearing means anytime up until the final judgment is actually delivered.
So even after all the evidence is in, but before the decision, you could still add someone?
Apparently so, if they are necessary.
Yeah.
And even more striking, in London and Goma, the Supreme Court said it has an inherent power, a built-in authority to join a party even after judgment.
Wow. But there are limits.
Yes, the Stanbic Bank case suggests that once everything's totally finished, no appeals, no reviews pending, it's generally too late to start adding parties. The proceedings have ended.
So there's a fairly wide window, but it does close eventually. I remember the hotelier case mentioning a possible gap in the Zambian rules about the how-to of joinder.
That's right. The Supreme Court pointed out that while Order 14 Rule 5 allows adding parties, it doesn't detail the exact steps.
So what was the suggestion?
They suggested looking to the English rules, specifically Order 15 Rule 6 of the RSC, which is much more detailed on the procedure.
And what does that English rule say? What needs to be shown to add someone?
Order 15 Rule 6(2) basically sets out the conditions. The person you want to add needs to have an interest in the dispute, or there's a question linked to the claim that also involves them, or, well, they're likely to be directly affected by the outcome.
So a real connection to the case.
Exactly. And Rule 6(3 adds that usually you need to file an affidavit, a sworn statement, explaining why this person needs to be joined, showing their interest.
And later cases confirm this idea of needing an interest or being affected.
Yes, the Mike Hamasan Wemba case reiterated that joinder can be ordered if someone has an interest in the subject matter or is likely to be affected by the result.
So it's all about making sure the right people, and only the right people, are involved for a fair outcome, even if you need to adjust things along the way.
Precisely. Fairness and getting a complete resolution. That's the goal.
Well, that was a genuinely deep dive into who gets to be a party in Zambian legal actions. I think the big takeaway is just how crucial it is to get the parties right from the start, or at least correct it properly, get it wrong, and your whole case could be in trouble.
Absolutely, it's foundational.
Yeah.
And we've seen the huge variety, minors needing protection, companies, trusts with special status, partnerships, unincorporated groups needing representatives, the state itself, all with slightly different rules.
It really highlights how layered the legal system is.
Hmm.
And thinking about all these rules, these potential complexities and just figuring out who should be in court, it makes you wonder, doesn't it? How does this impact real people trying to access justice?
That's a really important question.
What practical hurdles might pop up when you try to apply these rules in messy real-world situations? Definitely something to mull over. Thanks so much for walking us through all that today.
My pleasure. It's a fascinating area.